Most people think that a will is kind of all they need when they think about their estate planning. It's not. In Alberta, you need two additional separate documents which do two very different things. If you only have one or don't have either of them, your family could be stuck in court when you can least afford it for them to be. Today I'm going to explain both of these and why you need them. I'm Chad Graham. I'm a lawyer here in Edmonton, Alberta, and this video provides general information for education purposes. It does not constitute legal advice, and it does not create a solicitor-client relationship. For personalized advice to you, please contact your lawyer. Now, when most people think about estate planning, they think of it as something that kicks in after you die, so they think of the will with your executor and probate and all of that. But what about while you're still alive? If you were to have a stroke, be in a serious car accident, suffer from early onset dementia, or any condition that leaves you unable to make decisions for yourself, you'll need someone to step in. And unless you've signed the right documents in advance, your family has no legal authority to act on your behalf. That's where two documents come in: the enduring powers of attorney, an enduring power of attorney, and a personal directive. They're the documents you need while you're alive. They're going to work together with your will. And these three documents form what, for the average Albertan, is a complete estate plan. I tell every client the same thing. Your EPA and PD are more urgent than your will. Yes, you're going to need your will eventually, but when you do, you won't care. You might need your EPA tomorrow. An enduring power of attorney is the legal document that lets you appoint someone, called your attorney, to manage your financial affairs if you become incapable of managing them yourself. Now, the word attorney here doesn't mean lawyer. American television has once again led us astray. In the United States, they often refer to lawyers as attorneys at law because the word attorney means representative. So in that case, the lawyer would be a representative at law. But we don't use that designation in Canada at all. So when you think of attorney in this powers of attorney document, just think representative. It means there is a person authorized to act on your behalf. It can be a spouse, a family member, a trusted friend, literally anyone you choose. And under one of these powers of attorney, what can your attorney do? They can access your bank accounts and pay your bills. They can manage your investments and retirement accounts. They can deal with your real property, pay the mortgage, maintain the home, sell if necessary. They can file your taxes. They can manage your business interests, and they can make financial decisions on your behalf generally. A key word here, however, is enduring. A regular old power of attorney ceases to have any power or effect the moment you lose capacity. An enduring power of attorney endures, survives your incapacity, which is the whole point in this kind of planning. That's when you need it most. Your EPA is governed by the Powers of Attorney Act here in Alberta, and it must be signed while you have mental capacity. If you wait till you have incapacity, it's too late. You would be surprised how many people come to my office saying, my mom, my dad, my sister, whomever, needs a power of attorney. Oh, why do they need this? Because they no longer have the ability to take care of their affairs. Oh, unfortunately, it's too late. Don't leave your family in that position. Second document is that personal directive. It's a separate document, and it lets you appoint someone, here much more conveniently called simply your agent. Your agent can make healthcare and personal care decisions on your behalf. This covers a completely different set of decisions than the EPA. For example, consenting to or refusing medical treatment, deciding where you are to live, whether you stay at home, for example, or move into assisted living, or enter into long-term care. They can make decisions about your personal care, your daily routine, your diet, your social activities, and whom you can associate with. It also can give power to make end-of-life decisions on these really important matters, such as whether to continue life-sustaining treatments, palliative care preferences, and organ donation. Your personal directive is governed under the Personal Directives Act in Alberta, and you can use your personal directive to express your wishes directly, not just to appoint someone to decide. For example, you can write specific instructions about the kind of care you want or don't want, and your agent is bound to follow these instructions to the extent possible. This is especially important for end-of-life decisions, which are deeply personal matters. If you have strong feelings about life support, resuscitation, palliative care, etc., your personal directive is where you can put them. This makes sense now as to why you need both. An enduring power of attorney does not cover healthcare decisions, and a personal directive does nothing for financial decisions. They're two separate documents with separate legal frameworks. If you only have an EPA, your attorney can pay your bills and manage your money, but they have no authority to consent to that surgery, to decide on a care facility, or to make any end-of-life decisions for you. If you only had a personal directive, your agent could make health decisions, but they couldn't access your bank account to pay for that decision. You need both, and you should appoint the best person to be your representative. While it can be the same person, it needn't be. You can pick the right person for the finances and the right person for medical care. Your spouse, for example, might be the right person to manage your finances, but if you had an adult child working in healthcare, they might be the ideal person to deal with the other one. You have complete flexibility here. Now, what happens if you don't have these documents? If it becomes too late? Well, if you become incapacitated and don't have an EPA or personal directive, your family will have to go to court. They have to apply to the Court of King's Bench for an adult guardian and trusteeship order to be appointed as your trustee for financial matters, or your guardian for personal matters, or both. This process takes months. It is not a quick application. There are assessments, affidavits, court filings, and potentially hearings. It can cost thousands of dollars in legal fees, court costs, and capacity assessment fees. It requires ongoing court oversight. A court-appointed trustee or guardian may need to file accounting and reports to the court. Your family has a supervisor looking over their shoulder. And it can also create family conflict. If family members disagree over who should apply or who should be appointed, you're looking at a contested hearing, which adds even more cost and more time. All of this is avoidable by careful planning. An EPA and personal directive take about an hour to put into place. They cost a fraction of a trusteeship or guardianship application, and they give your family the authority to act immediately without court involvement. Now, for both these documents, there is a mechanism of engagement. But for the EPA, you have a choice. You can have a springing power of attorney or an immediate power of attorney. Immediately means your attorney's authority begins as soon as you sign. They can act on your behalf right away, even while you still have capacity. This is useful if you want someone to manage your finances day to day. For example, if you travel frequently, snowbirding maybe, or you simply want help with banking and bill payments. A springing EPA is quite a bit different. Here, your attorney's authority only springs into effect when a specific triggering event occurs, usually the determination of one or two physicians that you've lost capacity to manage your financial affairs. But unless and until that trigger is met, your attorney has no authority. Most of my clients choose the springing EPA. They want the protection in place, but they don't want someone else managing their money while they're still perfectly capable. And this gives them that control, but has the security backup. The trade-off, however, in having a springing EPA is that there can be a short delay when the trigger needs to be confirmed. Your family may need to arrange a capacity assessment before the attorney's authority kicks into place, but in practice, this can be done in just a few days. Now, who do you choose? I tell everyone, choosing the right person is even more important than getting these documents right. Your attorney under your EPA and your agent under the personal directive do not have to be the same person, as I said, but they can be as well. The key thing is to choose the best person for each role. For your EPA, you want someone who is financially responsible, organized, and trustworthy. They'll be managing real money, your money. For your personal directive, you want someone who knows your values, who understands your healthcare wishes, and can make difficult decisions under pressure. I call this the 2 a.m. document. And always name an alternate for each role whenever possible. If your primary attorney or agent can't act or is unwilling or unable to act, you want someone right there in place who can simply step up without resorting to that court application. I very much encourage you to talk to your people before engaging them with this role. It can be a real surprise to say, hey, you've been named the personal directive for Aunt Sally. At Chad Graham Law, we prepare enduring powers of attorney and personal directives as part of every estate package that we do. They work alongside your will to make sure your family is covered, both while you're alive and after you've passed. If you don't have these documents in place, now really is the time. I've put a link below where you can get started from home. Or if you have a more complex case and lots of questions, you can book a consultation with me. Thank you for watching.